Great.
Sure.
Great. Good evening. I'm Matt Wellner. I am the one of the two builder developer reps and your chair this evening. I wanted to start by apologizing that I can't be there in person. My wife's traveling out of town visiting family, and I got to hold down the fort here. So hopefully I can man it well enough. Thanks for everybody for the strong turnout tonight. So I'll start by asking Elizabeth to conduct introductions.
Thank you very much. Good evening, everybody. How's the volume? Can you all hear online?
Yeah, sounds good.
Okay. We are testing Zoom for the first time this evening. We're navigating away from WebEx, so we're actually grateful to our folks online for helping us be our guinea pigs tonight. All right. We will conduct introductions. We'll do first folks in the room and then go to folks online. And we'll do staff and CWAC members concurrently. So I'm Jody Newtower, editor in Margins. Thank you so much, Jody. I'm Elizabeth Edwards. I'm chief of staff for Clean Water Services.
Terry Song, District 3 neighborhood. Glenn Fee, Environment 1.
Elaine Stewart, Environment 2.
Alan Jesse, Agriculture 2.
Mark Farah, Builder Developer Rep. Andy Haugen, District 4.
Sharon Lambos, City Rep.
George Marsh, Agriculture 1.
Rebecca Shell-Kenrick, District 1. Katie Ragsdale, Executive Assistant.
Joshua Bernier, Clean Water Services IT.
Let's go to the folks in the back of the room.
Jack Leon, Clean Water Services.
Happy Peter Clean Water Services.
Dale Peak, Washington County Citizen Action Network. Oh, Bob.
Not just a bump in the line. Bob Baumgartner with regulatory affairs.
Oh, I. Ditto.
Joe Gall, I'm the Chief Utility Relations Officer for the district.
Shannon Huggins, Community Engagement.
Okay, the folks online, going to attempt to do it in alphabetical order. By first name.
I think that puts me first. Ashley Farrell, business rep.
Deanna will be next if Deanna's available. Might not have her right now. Nisha.
Hi, this is Nisha. I'm the I'm the at-large rep.
And Ramesh.
Ramesh Krishnamurthy, District 2.
Much. And Chair Wellner, I skipped over you.
Well, yeah, Matt Wellner, chair for this evening, and one of the two builder developer reps.
Fantastic. Oh, and Deanna's on Max. Thank you for being safe. So folks have noticed this meeting is being held in a hybrid format for modern government here. It's being recorded by way of public record. Wanted to introduce our newest member, Rebecca Shaw. Is it Kenrick? Fantastic, representing District 1. So Alex Phan, our former chair, has rotated out. We're very happy to have Rebecca with us this evening. We also reappointed Glenn Fee for Environment 1. So these were some recent actions of the board. And one more announcement is, I think folks have grown accustomed to having Stephanie Morrison supporting us in an administrative capacity. Stephanie is still with the district. She's doing fantastic work, but she is no longer supporting CWAC. We have the marvelous Katie Ragsdale. So you'll see, I will be CCing her on email. She will be reaching out to you directly. So if you need anything, feel free to reach out to me or to Katie for any and all needs. I think I'm going to kick it back over to the chair to introduce our first item.
Yeah, you're gonna kick it to me and then I'm gonna kick it back to
There you
you.
go.
So, our first agenda item is, Oregon Public Meetings Law, Oregon Ethics Law, and Public Records Law. And, Elizabeth and Caroline, take it off.
I promise this is not just an ego trip for me. It is not normal for me to be the consistent presenter. But this is our first meeting of the CWAC year. We run through October 1 through September 30th. So this is sort of our first meeting of our calendar year. For folks who might not know, I already introduced myself as Chief of Staff. I'm still relatively new here. Less than 6 months on the job. My background is as a bar attorney. I've worked in government for many, many years, which is part of why I'm a portion of the team that would be giving this training. But I've been not on the council side, but on the lawmaking government relations side of the ledger for most of my career. I'm going to be giving an abbreviated version of what was in your packet. And I'm going to give the abbreviated version for a couple reasons. First, our General Counsel and Chief Compliance Officer, Carolyn Lobdell, wishes she could be here, but unfortunately family issues came up and she's not able to join. Are we gonna go? We're good? Okay, awesome. I didn't touch anything. Second, the state is working on updating public meeting law requirements for governments and advisory boards. And they have been delayed in putting together the final training on that front. So given those two facts, and that this is the first meeting that we are all together for our calendar year, I wanted to give you the Cliff Notes version. And our General Counsel and Chief Compliance Officer will come back in 2025 and do the full training. But as we are a public entity, you are all public officials, this is a good primer. So we're actually going to start with maybe. There we go. We're going to start with a little bit of background on the history, and then we'll roll into public meeting law, ethics law, public records. This one? All right, cool. So I know that we have different levels of familiarity with our organization. So I'll give the high level, but I'm also going to do a pitch. We have a training called CWS Essentials. So if this sort of entices you and you want to dig in deeper, we'll be holding our CWS Essentials in either late January, early February. My colleague Joe Gall will be helping to organize that, and we'll circulate information. So if you want to dig in deeper, we will have a training for that and we will welcome you. But we'll do the short version for this evening. So you'll hear us talk about how we are an ORS 451. What does that mean? So under Oregon Revised Statutes, Chapter 451, we are a regional county service district. It is a very particular kind of special district. And part of that means that the Washington County Commissioners are also our board of directors. They wear different hats. We are charged with wastewater, stormwater, surface water management. But when we were formed as the Unified Sewerage Agency, we just did sewage. I actually am wearing my USA pin this evening in honor of giving a little bit of the history. So that's what we used to be, USA, formed over 50 years ago in 1970. We became Clean Water Services in 2001. We got a broader mandate with that, right? We moved from sewage to stormwater. And you'll probably hear us talk a lot about stormwater over the coming year and into the future. And then in 2004, we were one of the first entities in the nation to get a watershed-based National Pollutant Discharge Elimination System permit, NPDES permit. This was a really big deal, issued under the Federal Clean Water Act. It allows us to combine the permits for our water resource recovery facilities and municipal stormwater system into a single integrated permit so that we can manage across all of our facilities and the watershed. pretty innovative, pretty interesting, pretty unique, even to this day. So how about CWAC? What is your all role in this and how do you relate to the broader organization? Since its inception, USA Clean Water Services has always had an advisory body. So you have a rich over 50-year history when you come to this meeting and you serve as part of this advisory commission. And in the beginning, there were 4 members from major pre-existing sanitary districts because we were combining 26, 27 sanitary districts. There were 3 members representing cities and 2 being appointed by the board of commissioners. And the advisory function was really around a lot of day-to-day operations. It was around contracting for services and materials, and it was getting really into the nitty-gritty. Now, over time, that's a pretty big burden for volunteers. It got more into the, long-term planning. It got more into the budgeting, finance, long-term planning piece. In 1981, the advisory commission was narrowed to only 5 members, 1 for each of the board. And that was it. And it was that way for 10 years. And then in 1991, it became kind of its current configuration of 15 members. And it's been relatively stable since then, right? So you have 1 from each of the districts and at large, and 2 from business, 2 from the development community, 2 from the environmental community, 2 from ag, and our non-voting member from a city and a non-voting member from Clean Water Services. So we've had this very stable form since 91, which is pretty good. So why go into all of this, right? Well, to give you a sense that you are a really important part of the government of Clean Water Services. You serve a very important role. You have a rich history. And as part of that, you're subject to a lot of the requirements based on state law. And we will have, again, I said our general counsel give the full training, but I'm going to give you the sort of high level, which is we're subject to public meetings law. The purpose of public meetings law is to make sure that the public knows what decisions are being made, what deliberations are going into those decisions, and what is the information upon which is informing those deliberations and decisions. So it's about being open, it's about being transparent. And that sort of spirit of being open and being transparent, you'll see throughout this presentation when it comes to public meetings law, ethics law, public records. So who's required to hold public meetings, right? A really broad array. State government, regional government, county, city, special district, municipal corporation, and boards, commissions, subcommittees, advisory groups. That pulls in us. As part of public meetings law, we have certain requirements, which means notice. It means allowing members of the public to attend. It means making sure that we keep proper records of this meeting. So we make sure to post about CWAC on a public-facing website. After the fact, we publish our agenda. We include the recordings of the meeting, and we include a meeting summary. Doesn't need to be verbatim notes, but a robust meeting summary. And we do these things because, 1, it's the right thing to do, and 2, because these are requirements under state law for us. There was a quiz in the packet. I'm not going to do the quiz, but just if you have a quorum of the organization getting together and making decisions, deliberating on CWAC business, that would then trigger public meeting requirements. So if 2 of you get together and want to talk about CWAC business, that's fine. If 8 of you are hanging out and talking about CWAC business and not letting me know, I mean, my feelings will be hurt. And also that's a public meetings law violation. I don't think anyone's doing that, but that's just something to keep in mind. So Oregon ethics law. Congratulations, you are a public official. I am a public official. Most everybody in this room is a public official. And it's defined really broadly. There's a hyperlink here, Oregon Government Ethics Law Guide for Public Officials. It's great. Actually, you know, if you want to nerd out on this, I recommend spending some time with it. One of the great facts that's in there is that there are over 200,000 public officials in the state of Oregon. So not to say that we're not special, but we are in good company. And based on the population of the state, it's almost 5% of the state. Although you may have some people that are serving in multiple roles, right? If we're civically minded, we might be showing up in a couple of different places. So if you are a public official, really the rule of thumb to remember is that you cannot use your official position for personal gain. That's the high level takeaway, right? You cannot use your official position for personal gain. And that means also for your spouse, for your household, for your personal business. Now, if you think there is going to be a conflict of interest, relatives, yes, all of these folks. If you think there is going to be a conflict of interest, you need to announce that in a public meeting. We send the agenda in advance. If you look through and you see content that you think, gosh, maybe this might be a conflict of interest, reach out. We will help advise you on how you would declare a notice of conflict of interest. Nothing bad happens. No one slaps you on the wrist. It's again about being open and transparent, right? That is the spirit of all of this. And then if we were to be having a vote, you would rescind yourself from the vote. But again, the spirit of being open and transparent in this space. And then public records law. This is probably the shortest of all of the elements of this. You abide by public records law, right? Anything that we produce is clean water services, all of the documents and memos and things that we produce as part of CWAC, those are all public record. If you email me or Katie, ask me a question, right, that could be part of public record. It could end up in a public records request. And so as someone that has worked in government for most of my career, I always have the front page test, right? It's anything that I write may end up on, I guess it's no longer the front page of the Oregonian, it's on Oregon Live, right? It's, so just think about the fact that all of these things are a reflection of not just you, but the organization, and that they are available to members of the public so that they can see what the deliberations are, what the considerations are as we are going through our day-to-day business. So that is, yeah, there we go, public records law. That's the Cliff Notes version. We will have the robust version from Caroline Lobdell later this year, but wanted to just kind of set those ground rules, set those expectations, and then offer, if folks have questions, comments, concerns, happy to chat now, later. Yeah.
Ramesh, question?
This question came up in our water board meeting and when we train on the same public records law. Can you clarify that even if there isn't quorum, we cannot discuss the special districts topics? I thought I heard you say as soon as there is quorum, it becomes a public meeting, but if there isn't quorum, we can still discuss topics or issues.
So I actually have this pulled out from the Oregon Revised Statute, and it says a quorum of a governing body may not meet in private for the purpose of deciding or deliberating toward a decision on any matter except as otherwise provided by, and it lists a few exceptions. Some of that has to do with executive sessions, but quorum is one of the primary thresholds for what triggers public meeting requirements.
Right. Okay. I think my question was more about what happens when there isn't a quorum. Suppose two of us meet, can we still discuss topics of relevance?
Yes.
Okay,
Yeah, because then you're not meeting a quorum threshold. It's not a public meeting. It's two individuals having a conversation.
okay,
But if you have a very small body, if you had a body of 3 people, well, then you've met quorum. So it depends on the organization and the size of the entity.
Elizabeth, I have a question that might spur other questions. I don't know. We'll see. So I sat on the Washington County Planning Commission for 10 years and pretty familiar with, I guess, the ethics laws related to the decisions and the recommendations made by a body that makes decisions and recommendations. And in particular, I mean, when we would deal with quasi-judicial issues, we had to be very careful about disclosing anything that might be a conflict, making sure that we disclosed any bias, making sure that we didn't talk outside of meetings. On legislative issues, it was a little more loosey-goosey because it was policy and not directly specific to a single piece of property or a single owner. It was less, you still wanted to disclose and make sure you got it out there, but it was less of an issue. We don't really do anything like that here. And yeah, we do have good conversations, but I think we had a meeting a couple months ago over at Durham, and we were talking about the dam and talking about pushing back on how costs were allocated to the dam and the impact that might have on clean water services. And for me, after several years of service on this group, that might have been the only recommendation on vote that I've actually ever taken on CWAC. So I think when we get into the larger version of this conversation with Caroline, it would help me to understand kind of how this compares to sitting on something like a land use committee where you really need to be cognizant of the ethics rules. Because I guess I have a little harder it's hard for me to make that bridge on this group, even though I know we are a public entity.
Thanks, Matt. It's a great question and comment. And I think the laws are the same, and then how it applies in the particular context of CWAC versus a land use committee. And I think for today, I'll flag it for Caroline and make sure that she incorporates it into the full training when she comes back in the new year. Is that fair?
Okay, great. Yeah, fair.
Yeah, appreciate it.
Any additional questions? I can't see, so you'll have to just speak up.
I think we're good.
Okay. No further online questions, it looks like. So at this point, we're way ahead of schedule, 10 minutes ahead of schedule. I'm going to turn it over to Joe and Bob to discuss our operating intergovernmental agreements and collaboration for the future.
We may get out of here early tonight. My colleague Bob comes up. This one? Yep. So I started earlier in the meeting, just as a reminder, my name is Joe Gall, the Chief Utility Relations Officer here at Clean Water Services. Bob's going to join me in this presentation. We're going to do this together. I've been with the district about 3.5 years. And as many of you know, I come from city government. I was a city manager in Sherwood before coming here. And I remember walking in the door and Diane said, oh, by the way, you've got these operating IGAs that all have to be updated by November 2026. And it seemed like, oh, no big deal. And here we are 3 years later. And as you'll hear through this presentation, we have a lot of work ahead of us. A lot of work has been done, but we still have a lot of work to meet that goal. My role is to coordinate and collaborate with all the cities, but a lot of the heavy lift in the last year in terms of the actual negotiations with Beaverton and Hillsborough and the other cities we've been working with has really been Bob and Jamie. And that's why he's part of this presentation tonight. It's not working. Which one? Yes. So we have operating intergovernmental agreements with all of our cities and many of the cities that actually are not in our service district. They're kind of in 4 categories, depending on the relationship we have with those cities. So we have regional service agreements with the largest cities, the 7 largest cities, where we provide the regional services. They provide the local services. So that's one type of IGA in terms of operating agreements. Then the smaller cities, which you see listed here, we provide both regional and local services. So the details of those operating agreements are slightly different because we wear 2 hats. We provide both levels of services. We have a county operating IGA that really does not focus so much on wastewater, but focuses primarily on stormwater and transportation projects. It's a unique animal, as I would call it. And then we have operating IGAs with Lake Oswego, the city of Portland, and ODOT also, which are unique. Both Lake Oswego and Portland, part of their cities are within our service area. Those tend to focus more on the finances and the wastewater aspects of our services. So our earliest operating IGAs that we've been able to find go back to about 1990. And that's that special time when we became from USA and became CWS. So there may have been earlier operating IGAs before that, but those are kind of the first ones that we have found in our records. Most of the current IGAs were all done in 2005 to 2009. So that was quite some time ago. They've been amended since then for various reasons, but most of the basic ones that we're still operating under are from that time frame. It is a requirement of our NPDES permit. And as I alluded to, we have a requirement that they all have to be updated. And you can ask Bob what updated means by November 2026. So about 2 years from now. Which is going to get here fast. I'm going to pass around, I didn't make copies of this, but this is the Hillsborough agreement. These are not 1 to 2 page documents. This happens to be 34 pages that really you can kind of skim through, and I'll have that, just pass that around. But there's a lot of details that go into these documents. I think I was going to hand it to you from this point.
That's correct. Thank you. And I will note one thing. As you look at that operating agreement, you'll find that it is very well written, very concise, reads smoothly. That's because Jody helped us out. So my name's Bob Baumgartner. I've been with the district a little longer than Joe. And what I want to do is give you a little bit of background first on the operating agreements. As he mentioned, it's been quite a few years since we have updated those agreements. And we still continue to work well with our co-implementers. And it's very clear that we do work within the cities. They do work with us. We at times exchange work. So it's good to have an understanding of not only who has ownership of some of our infrastructure, also who is responsible for maintaining that infrastructure. As things change and as we see growth, who is responsible for building and then taking over that built infrastructure. All that requires a lot of detail and all that requires a lot of finesse in how we exchange money, which Kathleen has helped us understand as part of the IGA. In addition to that, one of the reasons we do have to update that is our permit is a watershed-based permit. So we have one permit that covers the entire watershed. It covers stormwater and the municipal wastewater, including the collection system and treatment system, as Elizabeth talked about earlier. Very unique, a lot of advantage in that. We've talked about that before. It's really a great thing to do. But we are required to be able to demonstrate that we have the capacity to implement the permit and the authority to enforce on that permit if we need to convince others to comply with those permit conditions. And DEQ reviews our agreements as part of our permit application. In the last review, when we did the permit, DEQ also noticed it had been a while since we had updated our permits or updated the agreement, so they asked us to do that. They gave us a very strict time frame. We worked with DEQ to give us a little bit more time because we anticipated a lot of work on those agreements. One of the reasons we anticipated a lot of work on those agreements is things have really changed as cities have grown. And as this whole area has developed, we are seeing much different situations that we need to manage than we did 10 or 15 years ago. And I'll just give you one example. An example is with Beaverton. Beaverton is now really thinking about redeveloping their downtown area. A much different stormwater program than we have had to deal with before or have had to address before. We can compare that with the issues that the city of Hillsborough is wrestling with. They are mostly talking about big developments and greenfield developments, much different than what the city of Beaverton is looking for. So we have a broader program, and some of that is going in different directions. And so we felt we needed to be able to have an update of those agreements to be clear on how we handle a much more diverse world. And as the cities take over some more of that work and the responsibility, to be much clearer about who was responsible and what our oversight role was in implementing the watershed-based permit that provided the umbrella for all of this. And so as easy as that is, that's why we're doing this. It is, what our roles are, how we're dividing that responsibility up, how we share responsibility and where we share that responsibility. A lot of administrative process. Some of the cities for a while had talked about getting their own permit until they found out what that administrative process was for those permits. We looked a lot at where we could add value to the district as a program, and the regulatory affairs, especially Jane, who's not here, can really handle a lot of that administrative process. We're experienced in it, and the watershed permit has advantages, as I mentioned before. So we wanted to keep that structure. We've talked about the ownership. With ownerships comes a lot of financing questions, and how we finance either the existing development or how we collaborate to make sure that the finance covered not only our stormwater program, but our increasing complexity of the permit, our increasing complexity of what our limits are in the permits. We have talked a little bit before about PFAS and other pollutants that we are dealing with that we didn't have to deal with 10 years ago. So we anticipate continued growth in our requirements for treatment, collection, and in the stormwater arena as well. And one of the areas we really found that there was a lot of opportunity for discussion was in dispute resolution. As we noted, it's been a while since we've updated these permits. Apparently, both us and the cities are very good with our long-term memory, especially where that long-term memory focuses on things that didn't work out as well as they could have. And so there was a lot of angst in trying to figure out why we had so many harsh memories. And part of it was we did not have a clear dispute resolution. And so these things just kind of hung on for a long time, and we blamed everybody else and took everybody's heritage into question. And that's something that we really focused on trying to fix and repair. So the updated process, we did start off with going through the importance of the NPDES permit. We own that, but because we've owned that so much, cities didn't fully understand what the regulatory authority was and the regulatory responsibility was. When they begin to understand that, they start seeing the value that we add to that. And then we decided to, instead of just starting with our version of the old IGA or the city's version of the old IGA, after we talked through all of the history, unpacking that, spitting at each other for a while, we decided to rather co-create this IGA, starting with the clean slate, starting with the very basics about what do we want to achieve, what do we have to achieve, what the goals of our co-implementers were, what our goals were, and just hammer that out and use that as a blank slate for trying to rewrite the IGA. And another thing that we did to build up the peer-to-peer relationship was where we had some of the harsh points where For example, the city of Hillsborough was frustrated with us. We actually had them write that section of the IGA about how they wanted us to behave with them. And the inverse, we were frustrated with the city, we wrote that. And that worked out remarkably well. Because what we found is we really did have common goals. It was more of a struggle of how do you get there and how do you enunciate that? And I think we ended up with a much more proactive approach by trying to understand each other's perspective as we wrote through this. That's also why we had 15 different styles of writing in the first draft that Jody fixed for us. And as I mentioned, cities are taking on some of the responsibilities. We had to sort out what that responsibility was, how we manage the crossovers of those responsibilities, and what our role was with the ownership of the permit to make sure they met those responsibilities, or we would have some actions that we could take should they fail to meet those. And so we really talked a lot about what our compliance was. And I mentioned the cities, and I really should have said this earlier. The way I think it's best to think about that is we have a local program and a regional program. The cities or the county are doing the local program. We do the local program in the unincorporated areas. Think of that like the cities. Most of the stormwater, almost all of the stormwater is under the local program responsibilities. The sanitary conveyance is a split, much of it with the cities. We own the bigger pipes or the pipes that are under pressure, and we're responsible for the water resource recovery facilities. So we established a number of goals with that. We wanted to be very clear that we were meeting the regulatory requirements as expressed by EPA and DEQ, that we had the authority to implement the permit and that we had the ability to enforce on that permit if we needed to, if anybody was either violating a condition or causing us to violate a condition of that permit. So we had to work with how the cities really had the responsibility of the programs, and we had the oversight, didn't step on each other's toes too much. We are still working a little bit getting that straight as we work through the implementation, but it's working remarkably well, at least in my mind. To be able to show that we could implement the permit, we have to establish a lot of training protocols so that we strive for consistency and understanding what expectations there are, but recognizing that some of the cities are going to have different ways to implement it. We have a role of making sure that if they are going off in a different direction, that direction is still consistent and meets the requirements of the permit. Think of it as there's lots of ways to skin a cat, all sorts of alternatives. We want to make sure they're effective and that the city then has the ability to implement as they see is appropriate. That's had some remarkable success. The city of Hillsborough, for example, now taking over the fog program that we used to run for them, has a number of people that they've hired. They've hired fancy new Vector trucks that pick it all up so they can bring it to the plants instead of just pushing it in, put it in our digester. So actually getting more resources committed to areas where we have had problems, and the city is being very responsible in their implementation of it. We do the planning for the wastewater treatment plants and the collection system, the major collection system. Again, that's the regional program. Cities do the master planning for the local programs. When they do that, they agree to feed us information. So we're using a consistent base of information on growth and development in our planning processes. The sub-basin planning is an area that I think is very intriguing, especially within the stormwater program. Within our last permit, for those of you who remember those discussions, we talked a lot about some innovative strategies that we have incorporated into our permit that really link the stream restoration, stream enhancement with our stormwater requirements for what they call hydro modification. The goal of all of that is to make sure that we have streams that are stable into the future and provide those beneficial uses, provide those ecosystem benefits that we are looking for. And we integrated those. DEQ wants us to be successful with that, as does EPA, as do we. And so the cities have looked at our skill set and felt that we can manage that type of a program. They don't need to repeat that program at this time. So they're really looking to us to be able to provide that kind of support for them when they develop that more of the integrated stormwater approach. And then we are also invested into a long-term planning exercise so that we can be looking at not only for 5 or 10, 15 years out for our next 2 or 3 permit cycles, but we've also started a process with DEQ within our permit to have integrated plans. So we are working right now with DEQ on negotiating our next permit, if you will. That becomes really important because one of the things we want to achieve is a lot more input from the city on what we want to achieve, or for our co-implementers on what we want to achieve with that permit. To be able to give us time to run through all that bureaucracy, we've got to get an early start. So we're 944 days before our next permit application. We've already started it working with this, with our co-implementers. And so city's doing the direct implementation. I think I've covered much of this already. There's a lot to do with the exchanging of fees, the costs and services that we are working through. Cities are working through their costs and services. And we are working on, we being Kathleen, on how to effectively transfer that money in a way that's smooth and easy and covers everybody's needs. Master planning is going on, and as I mentioned earlier, a lot of we're projecting into the future. The easiest way to think about it is the co-implementers are implementing the local programs. We do the local programs for the unincorporated area, and then we have the additional responsibility to permit oversight and for planning and managing the regional facilities, which include pumps, big pipes, and our water resource recovery facilities. And there are a lot of shared responsibilities. And this is part of the collaboration that I had touched on earlier. One of the real interesting areas that we are starting to work on is our stormwater management plans. Remember earlier, I gave the 2 examples of Beaverton and Hillsborough, how they're going to develop different strategies for meeting their needs. We're going to make sure that we can integrate those into a stable report so that we can report that to EPA, DEQ, and make public how we are effectively implementing that stormwater management plan. We're going to be emphasizing adaptive management because what we believe we have found is as we look at our stormwater program over the years, it really hasn't kept up with the changes that are happening. And we can be more effective and more efficient with our public resources if we allow ourselves to do adaptive management. DEQ has agreed. They've allowed us to be very flexible with adaptive management in our programs. The capacity operation and management program is to make sure that as we work with the co-implementers that the wastewater still flows effectively and efficiently. We don't have SSOs and we have some common understanding of that so that we can help each other out if we need to. And we have those programs to rely on. Erosion sediment control has always been an important issue. There are state and federal permits and local permits that we establish to make sure that as development occurs, we don't have a lot of sediment coming off. The cities are going to take more of the responsibility for implementing that, and we're going to make sure that the oversight is there to ensure that those programs are implemented well, and it doesn't put us out of compliance with either our permit or the EPA permits. I've talked about training. Transfer of assets is really a process for what happens when an area gets taken over by a city as unincorporated areas get incorporated into the cities. There's a lot of questions about what the value of that infrastructure is, how you handle that infrastructure, making sure it's still in working order before somebody picks it up so we just don't hand over a problem. And we've agreed on some of the processes for how we will do that. And we've also been able to work through our first exercise of conflict resolution to resolve how, if we get in debates about how to do that, how we can best do that. So that way, our programs are working well. I've talked a lot about our co-implementers. As you heard earlier, there are a couple of entities that are there that are not our co-implementers. City of Portland and Lake Oswego, for example. The one area of the program that is regulated that we are required to update due to regulation is our source control program. We have to control all of the industrial commercial sources that discharge to our system. If they're in a city, we have to have an agreement for who's going to do those inspections, who's going to enforce those permits. So largely that's we will regulate that stuff that comes to us. And if we send anything to the city for an industrial source, we will do that. So we have to do that. It's under a different part of the permit, but we still have that commitment to implement those. And we talked about how we started with a blank sheet. We did that with Hillsborough, did it with Beaverton, and recently with the city of Cornelius. It's in review. But the advantage of that is, even after all that, we have set up a pretty standard format. And I think that's good, because I think what will happen is the rest of them are going to chuck along much quicker now that we have that format, have something for people to respond to. But you can see what that looks like as an outline. I think I've touched on most of those. We probably, how many pages of definitions do we have, Jody?
5 or 6.
5 or 6, yeah. We've got a language of our own. So if you really get bored, you can try to read our language and then understand it. But a lot of detail in working through this. And it's more than just Jamie and myself and the rest of the team. It's pretty much we touch on all aspects of our program to get these done. And it's a large team that's pulling it together. So I don't want to take the credit for all of that by any stretch of the imagination. And then the other thing that we have done is we've created an appendix, if you've seen it on the back. That's what I think most people are going to look at. Now, they're not going to want to read the language, but they'll go back to that appendix to see what their responsibility is and how we've divided that up. Everybody that we've talked to, the co-implementers and our own programs from Field Ops, do a lot of the on-the-ground implementation. I really like that appendix that we put together, and it's really helped us make sure that we do have all that detail that crosses back and forth between the appendices that people will look at, and having the language within the agreement to work through that. And that's pretty much it. So far, so good. We've gotten a number, or Hillsborough done, Beaverton is on the cusp of being done, as is Cornelius. What's that?
I can go through that.
Oh, and with that, let's turn it over to Joe.
Thank you, Bob. So I wanted to go through these last slides very quickly, just to give you a sense of what we've accomplished so far and where we're going. So Bob mentioned we started with Hillsborough, and as you can see on this slide, we've been basically working off a 2005 agreement. Oh, get in the box, thank you. So you notice we started that negotiation back in January 2023, and we completed it in December, so it took a whole year. It was not a year of coming up with language. It was actually most of that time, I would say probably 7 to 8 months, we're sitting down with Hillsborough staff and CWS staff and just kind of working through different aspects of our workload and why do we do things this way. Bob mentioned the importance of the permit. As a former city of Sherwood employee and city manager, I really did not understand how important the permit was to the work that CWS does. And I think that's the starting point when we sit down with our cities, is to really help them understand how that permit drives everything we do together. So we spent a lot of time building relationships, kind of burying some of the past history. People do have long memories. We were talking about things that happened 10, 15 years ago. Many of those folks were no longer with the city of Hillsborough or with CWS, but people were still carrying that around. So that was very valuable to go through that. But we got that accomplished in 2023.
Hey, Joe.
Yes.
What's an example of something people were carrying around? You both have mentioned that. What does that mean?
Any come to mind?
Yeah, a couple of them, there were a couple of issues that came up. One of them I had mentioned earlier about when land gets transferred in, it gets picked up by a city. And there was feeling that we ended up giving them pipes, infrastructure that were well past the optimum stage, that they were decaying. And so the city felt that that although Clean Water Services had been collecting money for that maintenance, the maintenance had not been done. And we left them with a bunch of pipes that needed to be rebuilt, refurbished. So they ended up with a lot of costs for that. So a lot of that is where we had not done transfers very well. Another area that was really sensitive was within the stormwater program, where some of the stormwater would be coming off of an unincorporated area. But one of the cities had built the infrastructure to treat that stormwater, that they felt they were getting they're having to treat something that Clean Water Services should be treating and paying for. So we went through a fairly extensive exercise to understand where that water went, how it went back and forth, and figured out who owed who what money, and it ended up coming up at a bit of a wash. So some of that was people had a smaller, narrower picture of an issue rather than the broad issue. And some of it, I think there were some hard feelings, and as I mentioned earlier, for which there was really good foundation. But the problem wasn't that somebody really tried to rip somebody off, in my mind, as much as we really didn't have a good dispute resolution. So it was never resolved, and it just kind of hung out in people's memory.
The other thing that I noticed in both jurisdictions is there'd be a disagreement at one level in the organization. And there was not a clear, like, what do we do with this in terms of elevating it to get it resolved, and it would just end. And people would just have bitter feelings, quite honestly. The other thing that I've heard from folks is that our approach now is different than maybe 10, 15 years ago. We had a more, I don't know if it's heavy-handed, but we were seen as the regulatory agency coming in to tell you what to do as the city. And now we're like, no, we're here to help you meet your community goals in the areas that we provide services, and we're here to figure that out together. So I think our approach has changed also, so we hopefully won't have those kind of situations.
Thank you.
Beaverton next week, actually, Tuesday night, the council will approve this agreement. This also took longer than a year. A lot of great work similar to Hillsborough. There was a hiccup on the financial end about an administrative fee that actually delayed the whole process for probably 4 or 5 months. And now we've got that resolved. And the other thing that we're finding is, and this will probably play out over time, is we get close to the end and then the attorneys get involved and start looking at things. So Cornelius, which we just started in April, we took the Hillsborough and the Beaverton IGAs as a starting point. And Cornelius staff like, this looks great. We just have a few questions. We think everything's going fine. This is now held up a little bit because their attorneys starting to ask questions. So that I think that could be delays when you start to have attorneys who have different viewpoints looking at things, that could extend things. But we're hoping to have Cornelius done by the end of 2024. We started negotiating with the county in March. You notice this one's going to take some time. We've got some history that we're working through. And there's also a lot of new staff at both the county and at the cities. So a lot of the folks that we're working with don't have long history with CWS. And there's an education aspect in terms of, you know, the work that we do, why do we do it, what's your role, and things like that. So I see this exercise, yes, we're going to have new IGAs that are more up to date, but hopefully we have stronger, better partnerships with our city partners that we can work through things together. The next slides are just our planned schedule. Sherry Lynn's like, you haven't talked to me about this, Joe. You wanted to start. So we're going to be approaching Tualatin soon and say, hey, we'd like to start the process with you. We're actually going to check in with all of our cities, and this may adjust depending on what the city's needs are. So some of these cities may go later in the process, some may go earlier. But we'd like to sit down soon with Tualatin. and King City. Those are our two next cities that we'd like to start negotiations with. Then North Plains later this year into 2025. This could change because North Plains is going through political changes in terms of their leadership. So they don't even have a city manager yet, although I think they just picked one. So when we approach North Plains, they might say, hey, can we go later until our council gets settled? This is probably not the right time to be negotiating an IGA. Durham will be in 2025. Then Tigard, Banks, Gaston, then Forest Grove, last but not least, Sherwood. And then once we're done with all that, we have the more unique ones that are going to be in 2026. So the city of Lake Oswego start in January 26 with our 2011 operating agreement. Portland also in January 2026, also operating off a fairly old operating agreement. And then the last one that isn't on here that I mentioned is ODOT, which is also a very unique operating agreement. So covered a lot of ground. Bob and I would be happy to answer any questions.
So this is, I believe, a little bit of a shift from past IGA negotiations where they were all together. And then we each had an individual, each of the cities or co-owners had an IGA, but they were basically structured the same. And I can understand, but I would love for you to talk about why you're negotiating separately with each individual co-implementer when the structure of the permit is the same essentially, and CWS's responsibilities are the same. And my second kind of comment question is, there's a vast difference between Banks and Hillsborough. I would argue that there's a vast difference between Tualatin and Hillsborough, and in terms of negotiating skills. And so how do you account for the negotiating skills? I mean, I feel like Banks is at a disadvantage to know how to negotiate. As an example, billing. I've heard that some jurisdictions have agreed to have CWS contribute towards billing and others don't. And so like, if you're a better negotiator, you get more. And if you're not as good of a negotiator, you don't get the same advantages. So talk about how you're thinking about those things.
So I can start off.
Yeah, no, go ahead.
Yeah, and so, you know, one of the points you made, the second point you made really influences my thinking, at least on the first point, and that there's a vast difference between some of the cities. Banks issues are different than Beaver issues with stormwater. And within our implementation strategy, such as the stormwater management plan, we want to give the city some of that opportunity as they develop their programs to develop their unique issues and how they want to address and respond to those issues throughout that stormwater management plan. And so to do that, we are looking at a much more adaptive program than we have in the past, where it was one stormwater management plan and we developed that stormwater management plan and then you had to implement it. And that was really kind of the negotiating position, much more of a strong command and control. What we're looking for now is a much more peer-to-peer interaction in developing those. And so the value added that we see is we can help make sure we're consistent with the permit. We can develop the administrative procedures so that we can do the reporting. But the cities would have more of the opportunity to manage their system in the way that they see it best. So that's why we're doing it individually rather than in one swell or one large group, because we do want it to be flexible instead of just a one-size-fits-all as described by us. There are advantages to doing it individually. I think what really drove us starting this is some of the angst that we had in the past that we needed to get through, and that was different for each city. And so rather than bringing everybody's dirty laundry up at the same time, we wanted to do that individually. I do think, though, that the point you make is absolutely true, that these are going to start looking very similar by the time it's all done. And so I think, as we found with Cornelius, they were very comfortable with the kind of the standard format that we had for the city of Hillsborough. And I think that is going to kind of carry on through as we work through this. It's a question I hadn't thought about. Maybe Joe can help this a little bit better, but what we're hoping to do in the negotiation is really arrive at common consensus rather than us trying to take advantage of somebody else or not. So we may need to give some thought about how we make sure that there's full communication on what their options are.
Yeah, and in terms of finances, I would certainly hope that it's pretty consistent across everybody, especially in the finance area. There is one issue in Beaverton that we dealt with of a larger finance. They agreed with most of it, and actually we landed on the, except for a few sentences, almost the exact language in the Hillsborough one. You know, the smaller cities, we do all that. And I don't think they're gonna wanna take on more financial responsibility. Banks is not necessarily wanna do that. But we'll see over the next 2 years. We should revisit this 2 years from now. Were we correct or were we not correct?
And I fully expect before this is all done, we will be getting together with everybody and taking a look at it, cleaning off the rough edge. So I expect everybody will have a chance to look at what everybody else negotiated with and doing anything. Okay.
Ramesh?
Yeah, thanks. So I learned a lot about these agreements. You try to cover a whole bunch of topics, mainly permitting and finances and so on. But I'm thinking, is there a need or a use for any such agreements with special districts? Probably like in the planning area, in the operations area. Has there been any kind of issues in the past that would make you think maybe we need an agreement not as detailed or as big of this? Because I sit on the water board for West Lope. I'm thinking there are some overlap areas. What do you think?
I have not heard anything from any of the special districts, like the smaller water districts or TVWD, that would dictate. I mean, it's a different relationship with those other special districts. We've never had operating agreements. We don't share responsibilities. They're not necessarily covered under our permit. These agreements tend to be focused on the permit and who's going to do what to implement the permit. And we don't work with your water district, for example, to implement the permit. So there hasn't been a need for an IGA per se.
What about planning? What about if West Lope decides to release some 1 million gallons of water into your storm drain? Issues like that for some, I don't know, flushing the pipes, or I'm thinking of some hypothetical situations, but you think there is really no issue or no problems with any of these special districts?
We'd want to know about that. So if you know something that you're providing a clue to us, there is other opportunities for special districts, cities, and the counties to, on a monthly basis, coordinate on various issues. And that would be a venue where something like that probably would pop up that we would need to work through.
And we do some ad hoc, and the point you made is a very good one. We have had problems where people have put too much water in our collection system, whether that's stormwater or sanitary system. We do have procedures that regulate and control that, so that and most districts understand those. Where we have had For example, with the new water system that Hillsborough is putting together, we develop an ad hoc agreement with them for when they give us information so that we can facilitate that process. But that's rather ad hoc rather than a broad agreement like we're working on with the co-implementers.
Okay, thanks for calling my district a good, well-behaved district, but what is the forum? Where is the forum where these conversations happen, or how does these things get initiated or resolved if there are any ad hoc or one-off issues of this sort?
Well, you can always start with me in my role, because part of my job is to coordinate and collaborate with all of our partners, including our smaller special districts. So that would probably be a good place to start, would be with me.
Okay, so Mike Grimm will call you if he has any.
Yes, and I see Mike usually once a month. He's at those meetings.
Okay.
We do talk.
All right, okay, good.
Not like there's no coordination or communication. So thank you.
All right, no, thanks for the response. I know this was kind of things that were going on in my mind when you're talking about all these agreements and what if scenarios came up in my mind and I had to ask. Thank you, Joe.
Thank you. Other questions? Go ahead, Glenn.
Yeah, I'm sure this is in here, but how do you account for, so these are long agreements, 15 to 18 years. And I saw this, I'll use the city of Hillsborough as a good example. It's right in front of us. That was signed last December. Hillsborough could bring up to 1,700 acres of green fields if the governor uses the SB4 power into the city, which changes it completely. So that's suddenly you have 1,700 more acres of impervious surfaces with plants and different usage. How is that incorporated into the agreement when something that significant happens or could happen?
So I would say that's not necessarily in the agreement. That's in the day-to-day, week-to-week, month-to-month communication and coordination that we're doing with Hillsborough and our other cities.
Yeah.
On an ongoing basis. So the Senate Bill 4, we've been talking with Hillsborough about those possibilities, as we want to be as prepared as possible for the what if. So it's those ongoing communications that the document would not have to be updated. Our master plan, for example, might need to be updated, and our capital improvement plan might need to be updated to address some unforeseen large development like that. But the operating agreement would not necessarily need to be updated.
It doesn't change it. So there's a bunch more water coming from those impervious surfaces, for example. That doesn't change that agreement.
And this is a 5-year agreement.
That's 5-year, okay.
Yeah, these are 5-year agreements. Sorry, long term. We don't want to be doing these every 10 to 15 years. We want to do them more frequently. The other things that we've incorporated in the Hillsborough and Beaverton IGAs, and I hope to see in the others, is each year ongoing coordination in meetings that need to happen to coordinate to make sure that communication is happening. So we're not caught off guard or surprised by some city doing something out of the blue.
Yeah, and the standard part of that meeting is to identify any areas within the IGA that may need to be updated and process those. So if there's something that's different enough that we feel we need to work through, there's a process for that. And, you know, 1-year meeting requirement, I think, is actually really a good requirement. That's something that we own to make sure that it happens. And if we think there's something we need to implement, that we can make that happen, at least on that type of time schedule.
Elaine, your hand went up.
I have several questions, not surprisingly. Okay, the first one is, as you've been going through these, have there been any kind of overarching or common thread policy issues that are coming to mind that might come in front of us?
Yeah, I think I would anticipate that you will see the stormwater management plans coming to you that we are starting to work on. I think there will be a lot of policy issues that will be developed with those. And a lot of just how do we get along with people and implement these programs will come with that. not explicitly in the IGA, but linked to it will be the design and construction standards that are going to change. Because I think what will happen is, or what could happen is within the IGA, the cities can either adopt what we've adopted or come up with something different. If they come up with something different, we need to approve that. We being Clean Water Services and the Regulatory Affairs Group will be taking the lead on that. I expect those kind of decisions will come here.
Okay.
Yeah,
So,
I was gonna say,
sorry.
stormwater, the work in stormwater is the work where there's a lot of debate, misunderstanding. And that's the area of our work with our cities that has the most angst, so to speak, and like trying to figure things out. The wastewater seems much more straightforward. We have our issues, but those seem more straightforward compared to stormwater.
So looking at stormwater, what, there was a mention in the slide deck of ecological approaches to stormwater treatment. One of the things I've been becoming more aware of is, I hate to use the word intersectionality, but there's no substitute for it really. Looking at climate change, looking at things like environmental justice, older apartment buildings, opportunities to shade where people don't have good insulation. That's kind of a public health intersection even, because we do lose human lives during these heat waves. I'm just trying to think of, in the stormwater management plans, how can, and if not CWAC, how can at least some of the interested individuals like me that care about this and want to kind of move this needle a bit, is there a way to try to take a bit more integrated approach in these plans to address things that aren't purely under the purview of the permit, but are also the right thing to do and long-term have greater benefits?
That's a tough question.
I know, I'm sorry.
I know but that makes it a really good question. And let me come at it in a little bit different way by identifying what I think one of the biggest hurdles we will have to address that intersectionality. Because that's something that we want to do. We talk to EPA, DQ, the regulators, the cities. Everybody seems to want to do it. And one of the big hurdles that we have is that it's much more certain to design and build concrete big holes in the ground, right? That way you've got it done. We've got an engineer. And if anything scares a lawyer, it's an engineer. Engineers designed it and said, yeah, here's my stamp on it. It works the way it's supposed to be designed to meet your regulations. That's what our regulations have been developed to do, right? And so that has a lot of safety, and moving away from that has some risk. One of the biggest issues that has come up in our discussions with the cities is if you build this green infrastructure, who's going to maintain it? Who's going to be responsible for it when the next ash borer comes out and kills the ash trees? And is that going to be a compliance issue? We don't think it's going to be a compliance issue, but it's a really good question about who's going to manage it, who's going to take care of it. And so we got to, as a society, build up the confidence that we can do this work and be in compliance, not have compliance issues. We're starting that discussion with DEQ as part of our integrated plan, which is really good. But those are the issues DEQ is going to wonder about too. They want it to happen. They want it to be successful, but they're wondering how they provide that regulatory shield for themselves and for us. So to answer your question, at least the way I think about it is, we as a society, you as the environmental representative, have to look for those forums beyond just us to argue that this is a good thing to do, that we can make it happen. Our role, as I said earlier, is to create the process and the infrastructure to say we can build this and we can management. We're working on that. I think we will get there. I don't see a hurdle with DEQ approving it, but we've just got to get ourselves as a society comfortable that that will meet our risk tolerance, for lack of a better term. Because I think you're absolutely right. There are all kinds of benefits well beyond environmental regulatory compliance that go with something that is going to provide that intersectionality. And when I think about climate change, I don't see how we maintain healthy streams unless we start doing something about our streams.
Last question, which is an easier one.
Oh, good.
Is there a tension in working on Clean Water Services responsibility for source control when the producer, the discharger is within a local jurisdiction under IGA? Is that something they're kind of happy to have you do, or how does that go?
There's a little bit of ancillary tension.
Okay.
Mostly when we think about the industrial discharges coming into our wastewater system, municipalities want us to handle that, and that's understandable. There's a lot of chemistry involved. There's a lot of engineering involved, that we have the infrastructure to handle that, and they don't want to build that up. It'll be duplicative. So again, that's value added. There will be a little bit of tension, less between us and the cities as much as I expect it will be with the cities and the industries, as the cities decide how much that they should charge them for their oversight and maintaining and keeping the pipes running down below those industrial sources, which has been part of the tension in the past. And then in the stormwater arena, with the industries, there are very heavily regulated industrial stormwater permits, as well as our own requirements for stormwater management that sometimes overlap. That tension's been very minor and resolved once we decided we could talk to each other. It kind of went away.
Great, thank you.
Good question. Am I understanding correctly that the local agencies in your district don't have their own NPDES permits?
That's correct. We have one watershed NPDES permit. That watershed permit covers our 4 publicly owned treatment works. By definition, the publicly owned treatment works include and incorporate all of the collection system. That's why our IGA has got to be very clear on responsibility for those collection systems. DEQ used to have some permits that did those separately, but they don't want to go there again. That was a nightmare. And it covers the stormwater as well. We also act as DEQ's agent for the industrial stormwater permit and the 1200C, which is the erosion control permit. I expect some of the cities will want to take over that agreement with DEQ to do some of the erosion control program.
Hillsborough being the one that comes to mind.
For what reason? They want to take it over? For what reason would they want to take it over?
Because they want to. I think it's mostly they feel that they can do a more responsive job of getting out there and providing the direct contact with them to get things fixed before it becomes a regulatory.
The inspections, yeah.
It's a resource. They feel they have, as a large city, the resources to be able to tackle it on their own. They need to work with us and be in compliance, but that's where we're trying to let go a little bit. Okay, you can have that responsibility as long as you're complying, and we have that oversight responsibility. I don't think all 12 cities are going to do that. Beaverton, for example, was not interested in that. So I think Hillsborough is kind of an outlier.
Okay, so ODOT does have their own NPDES permit. So I think there's some tension on overlap, ODOT facility within the county or within the district. Is that something that's resolved by the upcoming IGA?
That is something that will be resolved by the unique discussions we have. And you're absolutely right. ODOT has their own NPDES permit, so they have to meet those NPDES permit requirements. we have our NPDES permit requirements. What is also clear, but it's kind of odd, is even if ODOT meets their permit requirements would cause our stormwater to exceed our permit requirements, we're still held responsible for that, even if they were in compliance. So what we need to do is make sure that what ODOT is doing, when they're doing it, they're meeting our conditions for permit as well. And that's going to be a little bit of a struggle that we'll need to work through, but we'll get there.
Maybe you're all tired of talking about PFAS, but I heard you touch on it earlier and with quinone and everything coming up. I don't know if those are covered under your NPDES. I'm assuming not. You're planning ahead, these are 5-year plans, so.
We
how
are
reconciling them? How are you reconciling?
Sorry,
That's okay.
I didn't mean to interrupt, and I apologize for that. 6 ppd quinone is not part of our permit. As we've talked about before, we have invested in our laboratory so that we are able to measure 6 ppd quinone. Part of our permit requirement is under the adaptive management to tell DEQ where we're going to be looking differently, new things or new approaches within our permit. We are going to focus some attention on emerging pollutants, which will be the 6 ppd quinone and the suite of PFAS. So this winter, we expect that we will be doing some sampling to help us understand where the 6 ppd quinone is not only coming from, but where it's getting into rivers. We're relying a lot on past research that's up in Washington to give us a theoretical model that we will apply, and then we'll be testing that with our monitoring, and then testing what BMPs are effective with that. I think we've talked to this group about our PFAS program. We've got a fairly large effort at PFAS. We're focusing a lot of effort on source control. We have had a number of very successful efforts on PFAS control. We just today discussed with the landfill the treatment they're going to be putting up for PFAS. So we are seeing that as a benefit. We are seeing some reduction coming to our plants. We still think it's going to be a huge issue for us. We'll be doing some stormwater monitoring, and that scares us for what we will find, but we will be working on it. Did that answer your question? I kind of rambled.
I heard more to come. Is that?
Oh, yeah.
And you can see why we have Jody help me with my right.
Any other questions? These are great questions. Thank you, everybody. Anyone else?
I just want to say from the city perspective, as the city rep, I think I speak for all of the cities in that having clean water services as the permit holder is such a benefit. And I came from a city where we held our own permit, and it is a lot. And so to have clean water services be the elephant in the room and managing that, while there's some, there's some tension on various levels, but clean water services is an amazing partner to the cities. So thank you.
Thank you.
Great, good questions all. Thanks, Bob and Joe. And with that, we'll move on to public comment.
Matt, can I interrupt just for a minute?
100%.
Thank you. Mostly for those that have known.
Get in your box.
Thank you.
Yeah.
For those of you that have known for a while, I want to thank you for all the time you've listened to me. But this is my last rodeo. I'm retiring. Oh, no. So thanks for all your time. I appreciate all your interest and all the time you've listened to me.
These meetings have just gotten a lot less entertaining. Well, thank you. And
I said, Matt, we couldn't hear you. You were speaking when we were clapping.
oh, sorry. What I said was with Bob gone, these meetings have gotten a lot less entertaining, probably. So. So thanks, Bob, for everything. You've been awesome. And again, I'm going to now open up the meeting to public comment. I know Dale is here. Dale, did you want to take a couple of minutes to say something?
Yeah, I do, but last time I did that, it didn't come through, it was mumbled. Should I get up there where I'm boxed too?
Either that or you can, there's either way.
Okay.
Right there or up here.
LP Clean Water, White County Citizen Action Network. First of all, Bob, I really appreciated working with you, Bob, over the years. You've been so honest with integrity, especially with PFACs and sharing all that data. Clean Water Services is losing a real asset. So congratulations on your retirement, but I regret it. Okay, so two comments I want to make. Record keeping and public records requests. In the past, my experience coming to these meetings, there hasn't been adequate minutes and recordings. And so I really appreciate what's happened in the back now, that there is a way to be recorded and those now act as the minutes. And I appreciate Katie Ragsdale in the way of organizing that, because sometimes I want to go back and look at what was said and you put it by who said when. And Jody did that. But that was much appreciated. It's very helpful for somebody that wants to go back and use minutes to actually see what was said and decisions made. So thank you for that. Public records request, Crane Data Center is proposing a land use application in Forest Grove, and I'm trying to stop that. And in doing that, I have made a lot of public records requests, and one of those public records requests has been to Clean Water Services. And it's very helpful to me to know now that it includes emails, text messages, chat messages, voicemails, handwritten notes, calendar entries, to-do and task lists, and audio and video recordings. That's helpful for me to know now what is actually a public records request that can be made. And because one of the times I did lately, the first thing was said, well, I need to talk to my attorney when I did it, when I wanted to say that, well, okay, but openness, sharing of public records is very request, very important for people that are trying to hold people accountable and to get data. 2 minutes, you're really toast.
I was trying to stop you.
But I really appreciate the finished speaker, I really, really do. Not one that's polished, but one that's through.
Thank you, Dale. It looks like there's one other public comment from Deanna Johnson online.
Yes, hello. Can everyone hear me okay?
Yes.
Fantastic. Yes, my name is Deanna Johnson, and I've been a resident of Beaverton for the last 22 years after IBM bought Sequent Computers back in the late 90s. One of the questions I had asked Tualatin Valley Water a couple of weeks ago when they had their public meeting about the water rate increase was when they were planning to implement any type of financial assistance programs for their customers. And now while the CFO did share a few details around like a 20% discount solely around the cost of a CCF, when I inquired about CWS, they had no clue, hence my attendance today. So just for me personally, and some of the residents, of course, that are on a fixed income, I just kind of wanted to find out in this public forum if there are any plans on the radar to offer a program or funding to assist customers who may need assistance, and if someone could get back in touch with me. Is that a possibility?
Yes, Ms. Johnson, we'll make sure that you get a response. And I believe Sammy Magani from our community engagement team has been in touch and will continue to follow up.
Fantastic. Yes, she did mention that she has inquired about it as well, but I think once I actually got a response back from the CEO and the CFO back on September 30th that they had no clue, I thought I'd just come to the public forum and ask if there's something on the radar and if something could be implemented. So I look forward to a response, and maybe it's a CFO of CWS in this case as well. So thank you, and I give you your time back.
Yeah, thank you.
Thank you, Deanna. Any other public comment in the room or online? Seeing none, hold on real quick. Elizabeth, announcements.
Our next meeting will be Wednesday, November 13th. We will follow up with location and agenda soon. And our December meeting will be canceled. So our last meeting of the calendar year, 2024, will be November 13th. That's all for my announcements.
Great. I guess before adjourning, again, just to say, Bob, thanks for all your service to the district. You're absolutely fantastic, and I've always enjoyed you coming and speaking to our group, and you're always very informative and the smartest guy in the room for sure. So
Thank you, appreciate that.
all right, thanks much. And with that, we'll adjourn tonight's meeting. Look forward to seeing everybody in November.
Thank you.
Thank you.